have conviction in what decision we have taken. The court has given a judgment. Yes, we understand the court a bit. We are not happy with the judgment, and that's why we are approaching the Supreme Court. And we are confident that Supreme Court will overturn the judgment of the High Court, because the circumstances with which we have taken the decision, the government had taken decision, is justified, and the President rule was justified clearly.
Okay, let's come to the arguments a little later. I want to first put to you, Mr. Hegde, the comments the High Court has made, the observations it's made about the central government. It says the centre acted in blatant falsehood. It says the centre acted like a private party. Now, those are damning things for a High Court to say in a judgment against the central government, aren't they?
Absolutely. And the normal practice is that courts do not use harsh words. But here is a constitutional authority exercising a constitutional power. And the High Court asked for the basis of the exercise of that power. It appears that there were arguments of privilege made to the High Court, saying that those files are not, they don't want to show it, and all kinds of things seem to have been argued before the High Court. I don't think that there can be a more damning indictment. Maybe that will be one of the grounds of appeal by the government itself.
Pinaki Mishra, another thing that happened is this morning, and it happened actually yesterday night as well, the High Court asked the government for an assurance that the government wouldn't revoke President's rule and swear in a new government, thus making the entire case in front of the High Court infractious, and the government refused to give that assurance. And this provoked the High Court to say, how can you think of playing with the court? We are pained. That is again unique, isn't it? That the High Court should feel aggrieved because the government is refusing to give an assurance which the High Court believes legitimately it has a right to take.
Unquestionably, Karan, it's a savage indictment. I don't think in recent memory this sort of indictment has come vis-a-vis the central government. And you know, this is what gladdens our hearts from time to time, when these courts step in and show just how important they are as sentinels of both democracy and upholding the Constitution. And really my heart is today gladdened that the High Court has shown so much courage, the High Court has shown so much sagacity. They've used very harsh language, and I think it was completely justified. The central government took an obdurate stand. They were obstinate before the court. They told the court that you have no jurisdiction in these matters. They seemed to feel they were above the law. And I think that the law, you ever so high, the law is above you. And I just hope and trust that the Supreme Court will maintain the kind of fearlessness that the High Court has shown in striking down what was obviously one of the most unconstitutional acts seen in recent times.
Let's come, gentlemen, to the arguments that were presented to the High Court as the basis for declaring President's rule. And I'll begin with you, Abhishek Singhvi. Arun Jaitley, in his blog and even in interviews that he's given, vehemently there was a majority against the government of 35 versus 32. Therefore, the bill had not passed. It had been wrongly said to have been passed. The government had actually failed, and because it was a money bill, the government had ceased to exist. The High Court clearly didn't accept that. And that is a stunning rejection of an argument made by a former law minister and by the sitting finance minister.
Karan, that was the principal argument run by the Attorney General. The problem is that when you make statements in the public arena and the press arena first, and you check the law later, then you come a cropper. Let me tell you some basic facts which will startle you. The entire issue was whether the Speaker should have agreed to a division or not, namely voice vote or a vote by press of buttons. So the first point which the High Court has accepted of my arguments is that even assuming the Speaker decides not to have a press button vote but a voice vote, the scrutiny of that decision of the Speaker on the floor of Article 212 of the Constitution means courts can't look at what the Speaker does inside the House unless the Speaker goes and violates somebody's physical human rights. Second, to get round it, a bizarre argument was made. The argument was that 212 bars scrutiny of the courts but does not bar the central government from acting to impose 356 because the Speaker did not agree to a division. Third, the whole edifice of the AG's argument was that 35 out of 68 had asked for a division. The entire argument was that. The whole argument fell like a pack of cards when it was pointed out that in the morning at 10:30 only 27 BJP MLAs had signed a memorandum asking for a division. Number two, at 7:30 in the evening when the vote was taking place, there is no memorandum by the 9 defecting MLAs or anybody else seeking a division. At 11:30 that night, the 35 of them together for the first time sign a memorandum, repeat, for the first time, give it to the governor saying that we had sought in the morning, retrospectively curing a defect which didn't exist. So the speaker had no occasion to listen to 35 out of 68. He was at best listening to a memorandum of 27 out of 68 seeking a division.
Absolutely.
All this is noted in the High Court judgment. We argued it at length.
Absolutely.
But most importantly, Karan, lastly, if you accept the principle that a central government will sit with the binoculars if you accept the principle central government will sit with binoculars in Delhi, looking at every speaker in every hostile assembly, hostile in the sense of a state government of a different political color, and the moment he makes an error in the floor of the House, they'll impose 356.
Absolutely. Let me
what
bring
happens to 356? Rare emergency power.
Absolutely.
To be exercised upon failure of constitutional machinery.
You've made some very good points. They have reflections not just on Arun Jaitley, who was the original author of that argument about the government losing its majority over the appropriation bill. They also have reflections on the way the case was defended by the Attorney General. I'll come first to Siddharth Varadarajan and take up the implications and ramifications this rejection has for Arun Jaitley. Not only was Arun Jaitley the author of that argument that the government's majority had collapsed because the appropriation bill hadn't passed and that there was a majority of 35 against it, which now has turned out to be fictitious because only 27 had called for a division, not 35. But does this not weaken Mr. Jaitley's position? Because he was the one who met the president at 10 at night and presumably persuaded the president to sign that proclamation within 12, 13 hours flat. So is Mr. Jaitley, Siddharth Varadarajan, an embarrassed man this evening?
Well, he is, no doubt about it, because the legal strategy that he chose to prop up the government's rather weak case has come a cropper. But he is not the original sinner or the sole sinner, right? So the task of Mr. Jaitley as the legal brains of the Modi government, and this is with due apologies to the law minister, was to, in a way, come up with some kind of window dressing, some kind of plausible legal explanation for a decision that the government was determined to take on the basis of political calculations. And clearly, Jaitley may have been a part of that, but I think Amit Shah and the Prime Minister cannot evade responsibility, because a decision of this momentous import, imposition of President's rule in Uttarakhand on such flimsy grounds, obviously would have required the input and the leadership role of the Prime Minister himself and the President of the BJP. So given a rather weak case to plead for, Jaitley came up with a legal argument which has obviously not been convincing for the High Court at all, and to that extent his legal skills will certainly be, or his mastery over legal arguments will be questioned by his detractors in the BJP. But I think that there is a larger question of political liability which Mr. Amit Shah and the Prime Minister cannot avoid.
Saeed Zafar Islam, do you want to speak about that? Jaitley embarrassed because the window dressing he provided for a rather dubious case turned out to be insufficient. The High Court didn't accept it. And beyond that, the Prime Minister and Amit Shah were involved as people who took this decision, and the whole decision itself, as far as the High Court is concerned, is dubious and unacceptable. How do you respond to that?
Karan, first of all, let me clarify that we had conviction in what decision central government had taken. So there is no doubt about it that the decision which had been taken by the central government was right, and it was justified by even the President of India, and he was convinced that the constitutional machinery is not working in the state and the governance is not there and the President role should be imposed. So in a way it looks like that while we understand the decision of the High Court of Nainital, but somehow I feel also that the court has also questioned the the authority of the President of India. But as I said earlier, that we are not embarrassed because we know that what the decision has been taken in the, under the circumstances, and it was the most appropriate decision taken at that time, and we are going to approach Supreme Court and the decision. We are absolutely clear that hopefully the decision will get overturned in Supreme Court.
Now the second issue that arises out of the way the Supreme Court, the High Court has rejected Mr. Jaitley's argument is the question about the Attorney General's handling of it. I accept and admit that he had a weak case to defend. The question I want to ask you, Mr. Hegde, is did he defend it badly as well? And I know lawyers don't like criticizing other lawyers, but I'm asking you to be honest, because the line that the Attorney General took was to deny the High Court access to files, access to reasoning, to say that they had no right to expect it, these were privileged, and therefore that provoked the High Court to say, no matter how high and big you may be, the law is above you. Did Mr. Rohatgi adopt the wrong defense and weaken an already bad case further?
Well, Mr. Rohatgi was not alone. Mr. Salve was also there for the state of Uttarakhand. I'm sure that whatever decisions he took were dictated by the situation and were dictated by his instructions. Having said that, you know, in criminal law, the Rampol of the Bailey says, never plead guilty. So this was almost one of those classic kind of defenses where everything was denied. You may do that in ordinary cases when you are appearing for a private party. But when you do it as the first law officer of the country, when you are talking constitutional law, you have to rise above these things.
And he didn't.
I have said what I wanted to.
All right, but the corollary, which you're not making explicit, and I'll make it explicit on your behalf, is that this was a moment for him to rise and be above the politics of the occasion, and he failed to do so. He became limited almost to the extent of becoming a creature of the politics rather than rising above it. Let me put something else to you before I come to Pinaki Mishra, and I want to put that question again to Abhishek Singhvi. The second argument the government presented in court for removing and overthrowing the government and declaring President's rule, and this time it is an argument made by the Attorney General himself, was horse trading had begun, horse trading would have become rampant, that's why they couldn't wait for the floor test as determined first by the governor and secondly by the High Court itself, and an immediate dismissal was necessary. Once again, the High Court hasn't accepted it on two grounds. A, the CD wasn't verified, and secondly, the High Court said in its observations that if a government is to be dismissed for every solitary act of corruption, you will be dismissing every government in the country. How much of a rebuke is that, Abhishek Singhvi, to the Attorney General? Because this time it was his argument that was being shot down.
No, look, I don't want to get personal at all. This is not a question. I mean, he was probably doing his duty to the best of his ability. I don't want to say anything personal about somebody. You get it wrong, the High Court comes down on you. Doesn't mean that, you know, you can't ascribe motives like that. But what I do want to say is that the problem is that you get swept away in a sea of political emotion and you don't read the law. Forget these 2 points you just mentioned, Karan. It is clear from before Bombay, and certainly at least 20 paras in Bombay and 10 paras in Rameshwar. Remember, Rameshwar was fully a horse trading case when Mr. Bhuta Singh wrote repeatedly for 1 month in April 2005 that there is horse trading going on for 1 month. And the court said when there is horse trading, the best panacea is a floor test, not President's rule. What do you think? Horse trading will increase or decrease during the window provided by President's rule? It is floor test which will end horse trading. Now here you had a bizarre case from 18th to 28th, 10 days later the floor test is coming up. A single solitary unverified sting on 25th surfaces. Incidentally, Karan, on 26th evening when the recommendation came, it was unverified, the report came next day. The recommendation went earlier. But on that solitary basis you ignore 10 paras of each of Bombay and Rameshwar. Namely that the floor test 48 hours later should have allowed to go on. That would have stopped floor trading either way, horse trading either way.
Okay, let me bring it.
The obvious object was that never before in the history of independent India was 356 used to stop a speaker's date and a disqualification proceeding. That was the real object, according to us.
Pinaki Mishra, you've just heard Abhishek Singhvi say with great passion that the position taken by the Attorney General ignored 10 paragraphs of the Bommai judgment and the Rameshwar judgment, was the Attorney General wise to deliberately ignore that? Because obviously the line of defense he was adopting required him to ignore it. What I'm asking is, was he wise to do so? Because he's laid himself open to the criticism that you've just heard.
Look, it was the government that ignored the law. It was unfortunately we've discussed this before, it was the Honorable President, I think, who did not follow the law strictly. And therefore, the Attorney General was simply carrying a very poor case in court. And I know personally, having spoken with him, his heart was not in it. I think he, privately, I think, was of the opinion this was not the correct course here. I think he also tried to advise the government. But these are not matters that I can discuss in public. But his heart was certainly not in this. And this was basically a political decision which went horribly wrong, because it was born in pure sin. I think the whole idea was, by skullduggery, to bring down a elected government, poach on ruling party MLAs, attempt to rush through a floor test. So the whole thing was complete skullduggery from day one. And it's very sad that a number of very high constitutional functionaries, I think, fell prey to the government's design, supported the government's design, and that has now been set at naught by the High Court. So therefore, I don't think to blame the Attorney General in this matter would be fair.
Okay.
Because he was actually arguing a very, very indefensible case in court. And I think he did it as lamely as anybody could have.
Very quickly, Syed Zafar Islam, you heard Pinaki Mishra say that the Attorney General had confided in him that his heart was not in this case, that the Attorney General had advised the government against the declaration of President's rule, that the Attorney General was well aware that he was defending a very weak case. I assume what Pinaki Mishra says is correct, although he can't reveal details, and understandably he can't. But this is a very interesting, piquant situation where the Attorney General was telling, and we now know that from Pinaki Mishra, his own government, this is the wrong decision, don't do it. And yet the government went ahead.
Well, it's very unfair. It will be very unfair for me to comment on that, what Mr. Mishra is sharing with the public, which may have been or may not have been shared by